The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, everybody. Please be seated. Rachel, do you have a plane to catch? That was pretty fast.
8 years of doing this, so I got pretty quick at it.
Welcome, everybody, to the United States Court of Appeals for the Fourth Circuit. We have 3 cases on for hearing this morning. First up is 25-1372, Center for Excellence in Higher Education versus the Accreditation Alliance of Career Schools and Colleges. Mr. Abachowitz, I'm sure I butchered that, I'm sorry, but whenever you're ready.
May it please the court. This court in professional massage recognized that accreditors, like any other agency, can and do run off the rails, and that meaningful judicial review is essential to make sure that they play it straight in wielding what this court has acknowledged as significant quasi-public authority over member schools' access to federal funding programs. At a minimum, this judicial review requires looking at whether an accreditor employed fair procedures in a fair tribunal, and where there is reason to expect foul play, the court must also consider whether an adverse decision was based on a good faith, consistent application of the standards rather than improper bias and ulterior motives. The proceedings below fell short of that mark. CEHE credibly alleged that its former accreditor, ACCSC, violated CEHE's due process rights by withdrawing CEHE's accreditation, not based on a fair and impartial application of the standards, but rather in bad faith to save face and deflect scrutiny as ACCSC's own federal recognition was up for review at the Department of Education.
Can I just ask that bad faith argument, when was that first raised in these proceedings? I thought the bad faith argument was different before the appellate panel. Wasn't there a different form of bad faith you were focused on earlier?
Your Honor, we sought to show that the procedures that were employed with respect to CEHE were completely out of line with the procedures in...
That's like your disparate treatment claim, right?
Yeah, and I think it goes beyond disparate treatment, Your Honor. What we were trying to show is that...
Okay, I'm sorry, just when did this argument about they're trying to deflect attention from this other thing that's going on, I think in Colorado, when did that argument first surface?
We tried to raise that in the arbitration, Your Honor.
In the arbitration, okay.
The judicial review decision, yes. Now, CEHE, or my opponent...
So a central case for you is this professional massage case here. And the professional massage case, I would like for you to speak to that. But tell me the difference, or at least to the extent of what do you rely on in that case, it being a case that did not involve arbitration?
Yes, Your Honor. I think that raises a very good point. What this court in professional massage said is that that judicial review is a requirement in the accreditation process. And they explained in that case that the judicial check arose based on ACCC's and other accreditors' significant quasi-public authority over matters of significant public concern. Here, the ability for schools to access Title IV funding, which is the lifeblood of higher education funding in this country. Very few schools could operate if their students could not access that money. So because this judicial check arises out of these matters of public concern, it's not simply a matter of discretion to what extent ACCSC wants to submit to that judicial review.
At least if this is the case I'm thinking about. There's a motion to vacate, correct? There's a motion to vacate.
Yes, that is correct.
And
yes.
then there is a complaint.
Yes.
And the motion to vacate is premised on the actions of the arbitrator, and then there's a complaint about what the arbitrator did. correct?
I think that they were both, we intended those both to be kind of one challenge to the process under professional massage of challenging the procedures that we received, but more importantly, the opportunity to challenge the lawfulness of the initial withdrawal decision itself, which, you know, as we felt we needed to raise in this process.
That's the confusing part, is the Federal Arbitration Act in the Section 10 gives you 4 different ways in which you can challenge it. It seems like to me your focus is on the third way, that he's guilty of some type of conduct of not considering the evidence there. And then you have this separate complaint that was brought outside the arbitration to basically undo the arbitration. And I don't understand that. That doesn't seem to follow. And I'm not alone in it, of course. You know, there are other circuits that have looked at it, but speak to that, because, you know, when you're trying to cabin your argument as to what you're arguing here today, it seems to me the focus is on the Federal Arbitration Act and what the arbitration trader did in the case.
No, Your Honor, I think the focus is much more on the Higher Education Act and professional massage and the due process that we're entitled to receive under that. And because those arbitration procedures categorically denied our ability to seek that judicial review, which is mandatory for creditors to follow, they are unenforceable to the extent that they are being used to preclude us from raising the bad faith claims in federal court.
So just going back to the motion to vacate, it looked like in the district court you argued, as Judge Wynn suggested, that the arbitrator engaged in misconduct. That was the ground for vacating the award. But I don't see you arguing that in your brief on appeal. Have you abandoned that argument?
Well, our argument in that is that in the cases in this circuit that have addressed the arbitral misconduct, the focus is on whether the arbitrator provided a full and fair process. And our contention has been that
I guess I'm just asking you, I don't see misconduct under Section 10A3 anywhere in your brief on appeal, even though that was your argument in the district court. Are you still raising that argument that this arbitrator, by following the terms of the agreement, not allowing discovery, limiting the scope of review to what was before the appellate panel, that constituted arbitral misconduct?
Yes, Your Honor. It did
Okay.
amount to a complete denial of our right to a fair hearing on that. And the fact
So
that...
even though you're going to, that's in your blue brief somewhere, this arbitral misconduct argument?
Yes, I think in the reply, ACCSC, in their opposition, they did challenge that there is no arbitrator misconduct.
Right, because that was the only argument you made in the district court.
And we also...
vacate.
Excuse me?
As grounds for vacating the award.
No, Your Honor, I don't think that's a fair reading of the pleadings below and the complaint. I mean, we've consistently argued the main thrust is that these instructions in the arbitration procedures categorically denied our right to judicial review under due process and the full scope of that review, and are thus therefore unenforceable to the extent that they are barring our claims that we're trying to bring here.
Can I ask you a question about the procedural, the statute in this case? And this is related to Judge Wynn's question. You concede that these kinds of claims first have to be decided by an arbitrator under the statutory regime?
Under the Higher Education Act, yes, there is a requirement that parties submit to initial arbitration before they can bring any federal claims in federal court.
And that initial arbitration is intended to be binding or not?
Well, it's an interesting question, Your Honor. Our contention is that it can't be manipulated in the way the ACCSC has to insulate it from the judicial review required by professional massage in light of the significant public authority and importance that there is that check. It's not mandatory, but more recently, in November 2023, so about a year after we filed this case, the Department of Education actually did issue guidance explaining that that initial arbitration is just that. It's initial, and it's not intended.
But you do acknowledge that the grounds for you to challenge an arbitrator's award is under Section 10 of the Federal Arbitration Act, correct?
And to the extent, and under Section 2 of the Arbitration Act, to the extent that...
What under Section 2 gives you the relief here?
Because the arbitration award fundamentally denied us due process. It can't be used to enforce.
But to vacate, you have a motion to vacate. Section 10 says, in order to vacate an order of it, you have 4 grounds to proceed on it. As you answered to Judge Harris's question, you say it's the 3rd ground that is misconduct. If you don't say that, there's nothing else. You don't, 1, 2, and 4, I would say, you don't proceed under 1, 2, and 4, do you, under the Federal Arbitration Act, Section 10? Only 3, is that correct?
As the statutes that we named, Your Honor, but also to the, under, I think there's a broader picture here that.
Let me make sure I understand my
Yes.
question. Section 10 has 4 grounds. Which of the 4 grounds are you proceeding under?
We invoked Section 3 of those grounds under
And the
that
other
Section
3 you do not invoke.
That is correct, Your
And
Honor.
the basis under the 3rd ground is you're saying there's misconduct because the arbitrator didn't consider some evidence, which is the evidence of other institutions having been treated differently.
No, Your Honor, I think that's a little bit more, a lot more narrow than what
Well,
we're
then
arguing.
tell me, what is the basis of the misconduct that you rely upon to establish a vacatur under Section 10 of the Federal Arbitration Act?
Yes, Your Honor. The focus of those cases is that.
No. I want to know, what is the basis that you rely upon to say there was misconduct in this case by the arbitrator?
The basis is that we were categorically excluded from raising relevant arguments.
Isn't that just what I just asked you?
Yes.
I just asked you, is that the basis of it?
That is the
I'm not
basis.
trying to argue with you. I just want to understand your case because I want you to have a fair hearing. If I walk out of here and I'm just not understanding your case, that's not fair to you. I'm asking you to explain it so that we can understand your case. So if the refusal to hear this evidence, is that the evidence well, tell me, what is that evidence? So it makes you
Well, I think that's what I'm trying to explain. And again, I'm not trying to argue with you either.
But what is that evidence?
The evidence is beyond the record, looking beyond the record. So this
Okay,
is.
but can I just ask you a question? How can it be arbitral misconduct not to look beyond the record when the arbitration agreement says you can't look beyond the record? How are we going to say this arbitrator engaged in misconduct by adhering to the terms of the agreement?
Well, I agree, and that's why, because again, it's not looking at the intent of the arbitrator, but I do think that the more appropriate grounds to look at this from is from whether those procedures.
But you answered Judge Nguyen that we're here on the vacatur motion based on arbitral misconduct, and I just want you to explain to me how it's misconduct for an arbitrator to follow the precise terms of the arbitration agreement.
Well, I'll just say simply that our position on that is that the fact that the instructions required him to commit misconduct is not an excuse for committing misconduct.
Okay.
I think that is.
Are there any other cases that find arbitral misconduct in this form following the terms of the arbitration agreement? It just seems to me like if you don't like the arbitration agreement, if you think it's unconscionable or one-sided, you challenge it under Section 2, but that's not grounds for vacating.
Yes, and I think that's what in the complaint, in the procedural due process challenge that we raised on professional massage, that's what we're trying to do with that. And that's really the argument and the thrust of our argument in that case is that because professional massage requires this level of judicial review, that ACCSC has completely abdicated, insulated itself from, we have been denied due process. And under the Higher Education Act.
It's just, the massage case didn't have an arbitration agreement, and I guess my concern with the kind of thrust of your argument, as I understand it, is that you want us to say that an arbitration violates due process if it doesn't allow for discovery and things like that, whereas the whole point of arbitration, I thought, was these kind of streamlined proceedings that generally don't allow for discovery. So what are we getting into here?
Well, because the due process requirements of professional massage do not allow an accreditor to say you can only look at this one hyper-narrow issue. He could not decide whether or not ACCSC lawfully withdrew CEH's accreditation. That is what the judicial review is required for. He could.
I mean,
so
there's
just-
no discovery when you challenge an agency order. Like, you're stuck with the agency record, and that's that. And at least so far, nobody thinks that violates due process.
Well, Your Honor, I would push back on that because many courts have held that effective judicial review, you can't have effective judicial review where the agency gets to decide as a matter of course that this is the record and there's no challenge to that. There has to be some opportunity where there is indicia of bad faith and where you make a substantial showing. And that might be
But what-
difficult, that you
I'm
have
sorry.
the opportunity to
What
look at.
makes this case different, though, is the requirement to arbitrate. And that's what I was asking about earlier, is exactly what does that entail? What's the scope of the arbitration? How binding is it in the context of this statute, which seems to contemplate that a civil action can be brought by someone like your client if they're denied accreditation for some improper reason. But it says that, but then it also requires arbitration. So how do those two provisions work?
Again, as it said, there has to be this initial arbitration.
Is that binding?
No, I don't think that it is binding, Your Honor, because it has to, the judicial review required by professional massage has to be afforded to that. And also, as quickly with my last few seconds here before rebuttal, the arbitration award isn't a bar to CHE's bad faith claims because they did not comprise any part of the arbitration award. And I see my time is.
But the massage case says that you need like a substantial showing of bad faith before we kind of get into the due process area of things. Where's the substantial showing here?
Well, Your Honor, I think that's my point, is that we have been trying to make that showing from the beginning of this. And I see my time's expired. Is it
You can
okay if
answer.
Yeah, so you have to have the opportunity to make that showing. And that, again, is going to be a factual matter. We're here today on a 12C motion, which is whether we've stated a plausible claim for relief. So we certainly understand that the district court could eventually say, no, you haven't met your burden of showing the need to expand the record and get discovery. And that's going to make this a difficult case. But due process requires that it would at least have the opportunity to try, that we get the opportunity to make that argument and to make our case. And the district court may very well say, no, I don't buy it. But then, we don't have any due process to heard. We've had the opportunity to be heard. We've had a hearing on those matters. But to decide right now that ACC's record is complete simply because ACCSC says it's complete, that doesn't comport with due process. It doesn't comport with professional massage.
All right, thank you, counsel.
Thank you.
Mr. Shabelsky?
Good morning. If it pleases the court, my name is Mike Shabelsky. Along with Louis Powell, we represent the Accrediting Commission. The commission withdrew independent universities' accreditation because Independence University persistently failed to meet the graduation and job placement metrics required by the commission standards.
Trying to understand the posture of the case, it's really can get pretty simple about it. There's a motion to vacate 12C, but it relies upon the Federal Arbitration Act, Section 10, with 4 grounds to vacate. As I understand it, we're proceeding here on the 3rd ground, the question of whether there's misconduct, which boils down to this evidentiary presentation, which then gets very simple to say, are you entitled to come in and show evidence of probation and how you handle other universities, or must you just rely on your benchmark, or as Judge Harris say, follow the arbitration award? If it's that simple, that issue is pretty much straightforward. And the other one on the complaint is really a question of, are we gonna say that's a collateral attack? Because to give the relief here would be just to vacate the award. Is that a summary of this case?
Yes, sir, Your Honor, absolutely.
What? Well, tell me what, I'm trying to understand what more is there to say about it. I'm trying to understand this case to make it complicated enough so that we can spend a lot of time talking about it. But give me something other than that, at least from my perspective. My colleagues may have something, but I'm trying to understand what this case is about that makes it other than just a very simple case.
Well, one complication is, I don't know that I have an answer to this yet, is the statute seems to contemplate arbitration clearly, but your colleague on the other side says that that arbitration isn't binding. that because of the makeup of this statute that allows for an independent civil action to be brought related to claims of accreditation, that makes this somehow different. Well, two questions. Is the arbitration binding?
Yes, sir.
It is binding. Okay, so what's the purpose of this independent provision, Section F of the statute, that seems to contemplate a separate civil action?
Well, as we understand it, Your Honor, that in the event you have binding arbitration, and not all agencies have to make, not all accreditation bodies have to make their arbitration binding. That's a choice that the commission gets to make, and the people who elect to use that commission's accreditation process consent to.
So in this case, that was the agreed-upon regime, that it was going to be binding arbitration.
Absolutely. The instructions say the arbitration is exclusive and binding, and I believe in the complaint, the plaintiff here inasmuch admits that it is binding arbitration. And I think that goes to the heart of the matter, Your Honor. The plaintiff here consented to these arbitration rules that they're now objecting to. If they did not want to be bound by the rules that require binding arbitration, they had a remedy. They could go and seek accreditation with another commission. There are scores of them. They elected to stay with this body and are now bound by its rules. And I would add, Your Honors, that it is not unlawful for an arbitration agreement to dispense with discovery. This court recognized that as far back as 1980 in the Burton v. Bush decision, where you affirmed an award that was challenged because someone said, I wasn't allowed discovery. This court said, civil rules, the rules of civil procedure don't apply to arbitration, and the parties can agree to forego discovery.
So let me ask you about that. So the instructions are form instructions. Is there any ability on the part of the institution to negotiate a different kind of arbitration agreement that might allow for discovery? Is it a take it or leave it proposition?
I don't think that there is a process in the bylaws or instructions that allow, I think what you're referring to as a negotiation.
Right.
The negotiation comes up front when the school decides, votes with his feet, so to speak, to decide, I want accreditation with this commission and as opposed to all the other ones, and so I'm agreeing to be bound by these rules. And these rules have to be applied fairly and consistently to all the applicants, so we can't just make one-off exceptions for someone who decides they have buyer's remorse. And, there is nothing about the Higher Education Act or these claims that should say that they should be carved out from the recognized principle that discovery is not required in arbitration if that's what the instructions provide. The Federal Arbitration Act doesn't carve out anything like that. Rather, Section 2 of the Federal Arbitration Act obligates courts to enforce arbitration agreements as
Explain
written.
what seems to me somewhat odd. The Department of Education has the authority here, and then you have this act. And then if you want to have an educational institution, you then go find accrediting agents. Is that right?
Yes, sir.
They pick it. And
Correct.
and then that's overseen by the Department of Education. So herein is an arbitration agreement, as Judge Diaz has pointed out. Are they bound to go this way? I don't understand how you pick an of course, I don't understand the whole process in terms of this accreditation. How many of these agencies are there out there? And it must have been a reason why they picked this one and stuck with it for a long time. Or maybe you just can't switch back and forth to one. I don't understand that.
Well, there are scores of these commissions recognized by the Department of Education. That's just a matter of fact and, public domain. The reason why the plaintiff here chose to seek accreditation for Independence University, that's not in the record. And their arguments don't turn on that. And so I think what the court's faced with is this plaintiff elected to seek accreditation with this commission and agreed to be bound by its rules and is now trying to be excused from the consequence of its decision.
One of the bases for challenging an arbitration agreement is misconduct by the arbitrator. You agree with that, right?
Misconduct by the arbitrator in refusing to hear material evidence.
Okay. But not misconduct external to the consideration of material evidence. Is that your
Not under
position?
10A3. That's correct, Your Honor.
So a claim of bad faith related not to the consideration of evidence, but something outside of the record is not something that this agreement contemplates.
Now, are you asking about bad faith by the arbitrator?
Yes.
Or bad faith? There are other grounds for challenging an arbitrator, perhaps that touch on those things, like
Or evident
bias,
partiality,
or other things like that by the arbitrator. But that's not the allegation here, Your Honor. There's no allegation in the complaint or the motion to vacate that the arbitrator was personally biased or anything like that. The bad faith argument arises, according to the plaintiffs, they say that the commission acted for protectural reasons, that their decision wasn't based on a good faith assessment of their failure to comply with the standards, but were trying to deflect attention or scrutiny from the Department of Education. And I think this then goes to a question, Judge Harris, you raised, and I wanted to make sure the record's clear on that. The plaintiff did not raise that argument about pretext until the arbitration. And that's important because they didn't argue it before the commission, when the commission was making the decision, and they didn't argue it before the appeals panel. They could have done it at both times because they knew the facts that they cite and rely on, the letters between the department and the commission about this Colorado decision that
What
they
I
say.
don't understand is, even if they did raise it now, I think I just heard the other side say they're only proceeding under Section 3 number 3 under Section 10. Section 2 is where there is evident partiality or corruption in the arbitrators. That's where you would bring that bias type thing. So even if it did, what I've heard here so far today is we are dealing with this misconduct part of Section 10.
I agree with you, Your Honor. And
So-
I believe, Judge Harris, you asked, was there ever any court that found arbitral misconduct under 10A3 where the arbitrator followed the rules and the aggrieved party didn't like the arbitrator doing that? The answer is no. We found none. I assume the plaintiff has found none because they've never cited any. The only case they've ever relied on to try to argue misconduct below, and I think here too, is this Marabone decision that this court issued. In that case, the court did vacate an award where the arbitrator refused to hold a hearing and receive evidence. But significantly, unlike this case, the arbitration agreement in Marabone expressly required the arbitrator to hold a hearing and received evidence. And in holding that that was misconduct, this court emphasized that the arbitrator was required to follow the rules. And when he didn't, his deviation from the rule was something that was the misconduct that deprived the full hearing. So Marabone doesn't stand for the proposition that this court has some sort of roving commission under Section 10A3 to look at the rules, the arbitral rules, and decide whether you think that they're fair or not. Rather, that is a matter for the parties in their agreement. And Section 2 of the FAA obligates this court to enforce the arbitration agreement as the parties have set them.
Can I ask you a question about the scope of review in the arbitration agreement? So what happens, and I understand this is purely hypothetical, but what happens if it turns out after a case has been to the appellate panel, evidence emerges that the commission, say there was a conflict of interest, like a financial conflict of interest, but nobody knew about it till after you have the appellate decision. And as I understand it, the arbitrator's scope of review is limited to what was in front of the appellate panel. So then what?
I would say it's the same thing that happens as, for example, if in professional massage, after this court's decision, evidence of financial bias emerged then. I mean, we do have rules of finality, we have rules of res judicata. But now, in this particular context, Your Honor, the grounds for the alleged bad faith.
No, I'm sorry, I didn't quite understand that. So
Oh.
the answer is the arbitrator can't take account of that.
That is right.
Okay.
But the way these rules are set up,
And then what happens after that? Like, does that mean the thing just stands even though there's an evident conflict of interest because finality?
yes, ma'am.
Okay.
And that happens in lawsuits all the time. But the way the rules work here, though, and for this specific allegation of bad faith, the rules are designed to encourage the school to present its arguments and grounds early in the process when they're dealing with the commission. And this is not was a 2+ year process. Anytime during that 2+ years, they could have made this argument about pretext. It encourages to say you then have to make that argument before the appeals
No, I
panel,
know,
but
but I
they're
was
trying to
asking
nip it
you
in the
about
bud.
what happens if the evidence doesn't come to light until after the appeal.
Recognizing that that wasn't the case here, but in
that's why I
that
said it
case,
was
Your Honor, I think
hypothetical.
it may well be that, if it emerged years after the fact, right? It's going to be just too
Well,
late.
It's a little different if it emerges during the course of proceedings.
No,
There's
and
no
I-
final judgment.
I understand why the court might be thinking about the consequences of that, and that could pose tough choices that have to be made there. But I think, Your Honor, if we've gone through the process, you agree to binding arbitration, you have it, and there aren't grounds for vacatur under Section 10, the FAA says that's final. There's nothing, professional massage did not hold that parties could not agree to binding arbitration and to adjudicate their claims in
Do
arbitration.
you know why there wasn't an arbitration agreement in that case? I thought everybody had to arbitrate. It's weird that we have this one big case on this, but it doesn't involve an arbitration agreement.
As I understand it, Your Honor, the commission, which was the party in professional massage, did not have binding arbitration rules at the time that the professional massage dispute arose. And so these arbitration rules were promulgated and became part of the commission's bylaws and instructions after the relevant time frame in professional massage. And there's nothing in professional massage that says, oh, a school has to be able to raise these claims in federal court. And that would be passing strange for the court to make that holding, because in all manner of cases, federal courts recognize that parties can agree to arbitrate all manner of federal claims, including federal statutory claims. And that is what happened here. And really, if you step back and look at it, Your Honor, the school here got all the due process that this court held in professional massage was required. It got ample notice of the commission's belief that they weren't in compliance. They were given written grounds as to why they were not in compliance. They had an ample opportunity over 2 years to demonstrate compliance or make improvements to meet our standards. In fact, they were given more time than the commission standards require because the commission agreed to an extension. They were allowed to respond in writing to all the cited shortcomings, submit whatever documents and information they had to state their case. As the arbitrator noted, some 32,000 pages of documents they submitted. And then they had an appeal before an independent panel in which they could raise any grounds they wanted, and they had the assistance of counsel. That is the exact process that this court held in professional massage, satisfied due process. In fact, you wrote on page 174, quote, "We do not think due process required more than that." So they got the plaintiffs here got all the process that this court blessed in professional massage. And of course, there was the substantive, findings that the withdrawal decision was based on substantial evidence.
Can I ask a question about one of the claims that your colleague on the other side raises on behalf of the institution, and that is that they were treated differently than other similarly situated institutions, and they weren't allowed to present that argument or weren't allowed to procure discovery to support that argument. So I guess the first half of that is, the agreement says what it says, you're not entitled to discovery. But if they had independent evidence outside of discovery that they could present to the arbitrator, would it have been error for the arbitrator not to consider that argument?
If they had submitted evidence, yes, it would have been error for him not to consider it. I don't know if it would necessarily have been misconduct.
Because I thought your client's
But-
position was that each institution is evaluated independently. The file is the file, and you don't consider evidence of other institutions.
That is our position.
Okay.
But also, that's the holdings of several federal courts, including courts in this circuit, that evidence about the rulings in other schools don't bear on whether or not there was substantial evidence for the immediate revocation decision. But, Your Honor, I want to make sure you're clear on something here. This plaintiff here was allowed to raise that argument and did, in fact, raise it and present evidence on that point, both before the commission during this 2-year process where the parties were engaged in the dialogue before the withdrawal decision was made, as well as before the appeals panel. They submitted, the plaintiff that is, submitted evidence regarding, I think it was 3 other schools, maybe 4, because that information is out there in the public domain. So the rules didn't prohibit them from making that argument. They did submit the evidence that they had, and that evidence was considered by both the appeals panel, which considered it and gave its reasons why it didn't think it mattered, and then it was raised again before the arbitrator, and the arbitrator considered that evidence and addressed it in his award and went through the analysis as to why he didn't think it changed the ultimate conclusion that the commission here had provided due process. So it was submitted and considered and rejected, and now that finding, whether you think it's right, wrong, or somewhere in between, we think it's right, but under the Arbitration Act, that was a decision for the arbitrator. And under the Federal Arbitration Act, a federal court can't now come in and say, well, we want to look at the merits of that and see if the arbitrator got it right. That was a question consigned to the arbitrator by the agreement. And at the end of the day, we haven't talked about the collateral estoppel. I did want to make one point on that, Your Honors. Counsel argued here, he said he did view those claims as one challenge to the withdrawal decision. I think that tells you everything you need to know about the collateral attack. Those damages claims seek to relitigate whether or not the commission afforded the plaintiff due process. And that was a finding that the arbitrator made in his ruling on page 35. He wrote, "The tribunal must decline to reverse the appeals panel decision on the ground that it deprived independence of due process." That is a finding in the arbitration. Their damages claims and that they've asserted in the complaint seek to relitigate that decision and nullify its effect, and that is a classic collateral attack. Thank you, Your Honor.
Thank you, counsel.
Thank you. First, I want to quickly address that there was no collateral attack here. The claims and the harm that CHE brings existed long before and separate from the arbitration. We're challenging the unlawful withdrawal decision and the resulting closure and loss of contracts. That happened well before and independent of the arbitration, which the district court agreed to when it said that if that initial arbitration decision was unlawful, then it was the proximate cause of those harms. Also, the arbitration award cannot, or the bad faith claims cannot comprise the arbitration award because, again, they were excluded from consideration entirely. And I think that's important in this arbitration that we were categorically barred from the arguments that we could raise. We could not challenge bad faith. And they harp on and talk about discovery, but we were only asking for the opportunity to expand the record. And the evidence that we provided was to make that showing. But the arbitrator, it's important, did not consider the merits of whether we showed the entitlement to discovery, and nobody has. We've been bound by
this idea that This isn't a collateral attack because your bad faith argument wasn't heard. So how can it be a collateral attack? It just seems like where you're headed with that. The arbitrator didn't hear your bad faith attack because you hadn't raised it before the commission or the appellate panel. And the scope of review was limited to the record before those two bodies. It can't be the case that by forfeiting an argument before the commission and the appellate panel, then you go to arbitration, the arbitrator doesn't reach the forfeited argument, but now you're allowed to bring what would otherwise be a collateral attack because you forfeited this, and therefore the arbitrator didn't consider it. Do you see what I'm saying? That seems like an absurd result.
Well, I would like to push back a little
Sure.
bit. In the context of the initial withdrawal decision, I can't overestimate enough that for the probation period prior to that, ACCSC had commended the efforts and recognized, knowing that it would be years and how much time it was going to take, that good cause existed to continue to extend the efforts. When the withdrawal decision came, there was no reason before then that we would ever challenge them. This was a good working relationship. They were accepting of what we did and said that you have warranted good time to see these efforts through, subject to our close
Sure, I'm
monitoring.
not trying to make like a normative point about why you didn't raise it. I'm just saying, like, do you see the kind of weird result that we would end up with if we tracked your reasoning on this? That because an issue was not raised before the accrediting body or the appellate panel, the arbitrator didn't reach it, and therefore you can now bring an attack on the arbitral award that would have been foreclosed had this issue been properly raised.
But it couldn't be properly raised. That's the point. The arbitrator could only consider the one narrow issue. And to say, to take their interpretation of what this was would be, you could only challenge bad faith if the accreditor voluntarily offers evidence of his bad faith in the record, which is never going to happen. And on the substantial evidence review, I mean, as this court noted in professional massage, there's dozens of accreditation standards that involve highly subjective matters of broad discretion. Any accreditor with an axe to grind is always going to be able to go to a school and manufacture some compliance issue that has more than a mere scintilla evidence to support it or some matter of discretion. So what you're doing is you're effectively making their decisions unreviewable. We can't challenge the fairness of the procedures that we were afforded. We've been trying throughout this process to say, no, we are obligated to raise these issues of bad faith, and we've not been able to do it at any stage. Even in the initial appeal, you're limited to only the evidence that's in the record. That's unalterably closed. We tried. We were flatly denied. And we have to argue the grounds based on what the appellate, the initial decision said. We can't go beyond that record. An effective judicial review requires looking beyond the record where there's a significant showing that we've never been able to make. Also, just quickly, I want to point out that in professional massage, this court recognized that the accreditation standards and the processes that they employ are not matters of contract. They can be changed unilaterally. And they don't get to just decide what level of judicial review they want to submit to and whether they want to comport with the due process requirements. And I think that accreditors or this member school should be able to rely on the fact that they will afford due process. So the fact that they adopted this rule nearly a decade ago shouldn't bar the ability of the school to challenge the fairness of those procedures as they're being applied in an enforcement proceeding, which is exactly what we're trying to do here. As this was applied to us, we've been fundamentally denied any aspect of due process, and all we're seeking is our day in court. On 12C, we've stated a plausible claim to relief. And if the court decides that the procedures that we had were fair, then that'll be the end of the case. But I think there's substantial reason and factual issues of why that's not the case.
All right, thank you, counsel.
Thank you.
I want to thank both counsel for their excellent arguments this morning. We'll come down and greet you and move on to our second case. Our second case is 23-2310, Dominion Coal Corporation versus DOWCP et al. Ms. Barker, whenever you're ready.
Good morning, Your Honors. May it please the Court, my name is Charity Barger. I represent the petitioner Dominion Coal Corporation in this appeal of an award of federal black lung benefits. It's important to remember at the outset, Your Honors, that this claim was originally denied by ALJ McGrath. It was only after the board remanded this claim with instructions that the ALJ found that there was enough evidence to establish complicated pneumoconiosis. Our contention is that the board exceeded its authority by usurping the ALJ's role when it was bound to uphold the ALJ's original denial, so long as it was supported by substantial evidence, which we contend that it was.
Can I just ask you a quick question?
Absolutely, Your Honor.
Why, I just want to give you a chance to explain why we have jurisdiction to review the non-final remand order. And I guess if you would, why we can, but also kind of why we should.
Okay. So under 5 U.S.C. 706, this review in court is meant to set aside any agency order that's arbitrary, capricious. It's supposed to review all the entire record, and specifically looking for prejudicial error. So the only time that we come before this court is when we have a final decision. And so when the board remanded the ALJ's original denial, and then the ALJ, of course, awarded, then it was at that time that we were able to come back before this court to say that that original denial was actually supported by substantial evidence, and that the board was bound to uphold that denial. And the reason that is because federal black lung is different from other agencies. I believe that some agencies are allowed to do an independent review of the record, which federal black lung, that is not true. The only time that it's able to overturn any findings of conclusion, any findings of fact or conclusion of law, are if they're not supported by substantial evidence. And that's, the denial was supported by substantial evidence. This case is probably different from cases that have come before this court because legal pneumoconiosis is often involved, and that's a statutory pneumoconiosis. Clinical pneumoconiosis, or complicated pneumoconiosis, is a form of clinical pneumoconiosis, which is medical pneumoconiosis, and I know I keep saying that word a lot. But what we depend on in medical pneumoconiosis is the experts. The experts are meant to tell us what pneumoconiosis is.
So the problem is, at least, and I do like you to continue with Judge Harris's question in terms of whether that was, it is our propriety to review what internal remands process back down for the ALJ to consider it and then come back. Even if so, I mean, ultimately we got the whole case before us. If it was error, maybe it was or may not, we can determine that now. But ultimately, when you get into the question of whether this is complicated pneumoconiosis or simple, if you look at what the ALJ initially did, looked at both sides, and says, well, this doctor says this, one says it's simple, one says complicated, this says that. And he says that's in equipoise. And so all things equal, you don't get a presumption. And all they said is, no, you need to go back and give us a basis for seeing this. In other words, you don't just get to say the doctor said this conclusion or that conclusion and say they're all equal. You tell me, what is it about those opinions that you, when you look at them, you make those determinations. And I thought that's exactly what the ALJ did when they took it back. But you have a problem with that because you say the ALJ can simply say you got 5 on this side and 5 on that side, we're in equipoise, and therefore you get no presumption.
No, that's not what I'm saying, Your Honor, because that's a mere counting of heads, and that's not what I'm saying. What I'm saying is that the medical experts are the ones that have to explain this type of stuff to us. Now, when the ALJ originally denied, he looked at Dr. Adcox and said, You know, Dr. Adcock's believed complicated pneumoconiosis is not, that pseudoplaque formations are not complicated pneumoconiosis. And ALJ, Dr. Adcock explained that well to the ALJ. Now, the board might have thought the ALJ did not go enough into it, but what they're asking is that
But all the ALJ said, as I read the ALJ opinion, was like, as Judge Wynn said, 50-50 equipoise, and one is longer. One guy said more. But he didn't get into the content of the explanation at all. Is that sufficient? If, just assume for a minute, make it hypothetical, and ALJ says the evidence is in equipoise, but one expert said more. Is that enough?
Well, I mean, I think that there are situations where the evidence is balanced. You have like,
But is
Judge.
it enough for a tiebreaker that one guy used more words in his explanation?
Well, if he was more persuasive with his explanation,
But if
then
all the ALJ says is one explanation is longer,
one's more explanatory, yes, and that's the point, is that we have complicated pneumoconiosis, and the medical experts have to explain to us what it is. Dr. DuPont didn't give any explanation, just said this is 1 centimeter, greater than 1 centimeter, and therefore it's
Well,
complicated
let's make the
pneumoconiosis.
example more extreme. It's not just longer, but expert A's report is 5 pages, expert B's report is 10 pages. I like 10 pages. I'm going with that, without considering what's in the 10 pages.
No, I think that, yes, that is a little bit more extreme. No, I don't.
Isn't that what he did here?
Well, I think that what the ALJ was faced with was 2 experts that have equally different reasoning, but to go and say that you have to go back as an ALJ and say, where is the location of the nodule? What is the size of the nodule? What medical expertise is an ALJ have to do that? And when the board specifically said that you have to look and see if the nodule in the pleura is complicated pneumoconiosis, because we have determined before that that's true, and that's not true. There's nothing in the regulations that say a pseudoplaque is complicated pneumoconiosis. We have to depend on the experts, and if the experts haven't given enough of an explanation, I believe there's a way for the ALJ to ask for additional information on that. But that's not, even the ALJ's award of benefits does not really say anything other than what the board said, which is that a pleura, it's okay to be complicated pneumoconiosis, which is not in the
That
regulations.
first issue you did here deals with the merits and whether this is simple, complicated. You're right. It goes to what the experts actually say. You actually give a better explanation than the ALJ gave the first time, and that's the problem we're having.
Okay.
The ALJ was very simplistic, and that's why they sent it back to them. If you said what you said, maybe that would have been okay, but that's not, and maybe the record did show that that's not his decision on it. But and you can stay with this, but really the issue in this case is probably that constitutional issue you got in here on that ALJ. That's an interesting issue.
It
And
is.
It's one that is at the focal point. I don't know how much time you spent on it or whether you want to keep doing on this, but because when you look at what we did in the previous case here, it says, okay, we're not going to get to it because you can't show any harm.
Right.
And I'm not sure Collins did that. But we're bound by that case. We're bound by our case here. We can't change Keene, okay?
Right,
But I want you
right.
to I'm not sure it said, because Collins actually decided the constitutional issue there. It didn't just, and then it said there's no harm for you. But insofar as that constitutional issue, that FHA director, whatever, was gone. I mean, and everybody else like him, because then the powers were there. It said it was unconstitutional. I don't know what we do here, or whether that is still with us, because I think your case is just like the one that was here previously. You can't show harm if we
Okay.
rely upon that.
Yes, yes, and I know that the solicitor will get up and say that McMillan is longstanding precedent here, and so on all fours, it is exactly the same as Keene and versus K&R contractors. And what we said is that really, I'm sorry, I'm getting dry mouth here.
Well, it is, isn't it? It is on all fours with King.
The harm that we stated in our briefing was that the proceeding itself is a harm. And I guess the court and Keene seemed to not believe that that was enough, and that
That's
what we
standing
needed.
harm. That's why you're here. That's why you don't get, you have standing. It's
Right.
You can show injury for standing purposes. But the harm in this instance deals with the causation type thing. Did it cause you anything? That's a different type of harm.
Yes, and what Collins was a very unique situation, a unique situation because you're talking about retrospective and prospective, and it's very difficult to determine what relief was being looked at in Collins. Now, what Collins did that this court did not do is that it did decide the constitutional question first. And so what we have here is we don't have conflicting decisions on the constitutional question because Keene never actually addressed. It said, it jumped to the remedy and said, because there's no remedy, we can't address the
I
constitutional
don't think it
question.
said we can't address the constitutional question. I think it said we're not going to.
Right,
Right.
right. And what I've known, and I know I'm sorry. I know that I have a limited experience in this area, but what I have seen, is, even in Collins, is that question is meant to be addressed first, and then the remedy is next. And that the only way you can't,
Well, you can't know that because, I mean, you're dealing with, look at the Section 1983 cases. You can do, under Pearson, you can say it wasn't clearly established and never reached a constitutional issue. Sort of similar here. The difference here is we don't have a Pearson case. We got that case of the Supreme Court of College. Court did address the constitutionality, then for remedy purposes, says you can't show any harm.
Exactly.
But the constitutional question was addressed there.
right.
I assume you want us to address the
I
constitutional.
do want you to, yes, that is what I'm
Well, why should
asking
we
the
do
court.
that since you didn't raise it until after the ALJ got reversed on remand? You waited until the
we
decision
filed-
went against you, and then you raised forfeiture all of a sudden.
It was my understanding, and maybe I can look at that quick, but we did file a motion to have the ALJ removed, and in that motion,
But
we
when did you
did,
file that?
I'm sorry, let me bring this out here.
Maybe you can come back on rebuttal. and
Yeah, I can actually
answer
address-
But
address
I-
that on
I
rebuttal. I'll
think
be
you've
happy
got
to do that.
The point is, I think you may have a forfeiture problem.
Okay.
Because you didn't raise it until after the decision went against you.
Yeah, I'll definitely address that on appeal. But going to, even if this court,
Let me ask you just to check.
Correct.
Is that a jurisdictional question?
huh?
Is that a jurisdictional question here?
As to whether or not,
you have the subject matter jurisdiction to do something or the authority because it's unconstitutional. I mean, if it is, you can raise it any time, but look at that to see. That's an intriguing question, Judge Diaz bring up, that you didn't raise it. But I want to make sure we address it because I don't want to leave here and say, well, in my head, I'm going somewhere differently, but think about that.
Okay.
Is that a subject matter jurisdiction question?
okay, I definitely will. I know I only have a couple of minutes left, so I just wanted to address real quickly with the court, that even if this court were to find that the ALJ's opinion wasn't supported by substantial evidence, the denial, because he didn't go into more detail as to why he chose Dr. DuPont over Dr. Adcock, other than it was more explanatory, although I will again say that sometimes evidence is at equipoise, and that is something that an ALJ can say. But ALJ McGrath's award also has some very similar, not similar, but it has some flaws. For instance, discrediting Dr. Adcock because his opinion was against the regulations, and that's simply not true. And
Once the ALJ does in fact look at it as you would want him to do,
Mm-hmm.
what is our standard of review of what the ALJ did and what the board did? How do we review that?
what is the court's
Yes.
scope of review? Well, the court's scope of
Do we
review.
give deference?
Yeah, yes, to the ALJ's factual findings. The court steps into the place of the board, and they give deference. The court would look at whether or not the ALJ's decision was supported by substantial evidence and whether or not there were any errors of legal conclusion. So that's the board's role, and it's much like the Benefits Review Board, their role. And so what I'm saying is that they exceeded their authority by not by overturning or vacating this award that was supported by substantial evidence. If this court believes that it wasn't
You're still
supported,
talking about the first one.
the first one, the second
But
one,
if you can get from the
if we
first
get to
one-
the second
If you get
one,
from the first one to the second one,
it's,
you got a different problem.
I have a different problem.
Yes, because your first one is that they shouldn't have reversed the first one, but the second one
Right.
has all that's
It's-
in it. So that's why I said you have
A different
you don't,
problem.
but at least your argument is different on the
Right.
second one.
Is that
So
it
what is your
wasn't-
argument on the
That
second
it
one?
wasn't supported by substantial evidence.
Yes.
And the
Because
reason.
he actually did go through each one, and now you are saying our review, given deference,
Mm-hmm.
that this is not supported by substantial evidence.
Correct, and that's because of, one, that the board was incorrect when it said, I'm sorry, I see that I'm out of time,
No,
I
you can
finished
answer.
my
Go-
thought.
go ahead.
Okay, was that, first, that Dr. Adcock's findings, and the reason the ALJ rejected Dr. Adcock's findings is because they were against the regulation, because he did not consider that a nodule could be in the pleura, but that's nowhere in the regulations. And so we would say that it's not awarded by, it's not supported by substantial evidence, or that there is an error in the legal conclusion, because when you look at the regulations itself, there's nothing in there that says that a nodule in the pleura is complicated pneumoconiosis. Like I said, we depend on the medical community to tell us whether or not that is complicated.
All right, thank you,
Thank
Ms.
you.
Barber. Mr. Casserly.
Thank you, Your Honor, and may it please the court. My name's Dave Casserly. I'm representing the Director of the Office of Workers' Compensation Programs. I'm here to answer or to address only one question that this court has already answered in Keene, which is whether the appellant here must show harm resulting from the ALJ's double layers of removal protections.
You're going to talk about the constitutional issue, and I take it your other counsel will talk about the merits issue.
Yes, Your Honor. That's right, medical entitlement.
You want to
issue.
talk at all about forfeiture?
Sure, Your Honor. We don't think this was forfeited. It's at JA 49 to 50. They raised, well, let me put it this way. They raised a removal argument saying the ALJ's removal protections were unlawful to the judge in the first instance in a motion, as opposing counsel mentioned, and that's at pages 49 to 50 of the joint appendix. So we're not making any forfeiture argument on that ground. I will say, though, that they did not allege any harm there. It's not really a forfeiture issue, though, since they have never alleged any harm. They've never alleged any specific harm of the type that this court said would be required in Keene and that the Supreme Court said would be required in Collins v. Yellen. So that part isn't alleged. But yes, they did raise the issue below properly, Your Honor.
Your issue could be the big issue in this case. I mean, because to go in the direction of saying that these ALJs were unconstitutionally appointed, now you got the Ninth Circuit, the 11th Circuit, or opposed to one another in how that comes out, at least in the 11th Circuit, maybe 11, whatever, that deals with the SEC on it. But it's important because if we were to find or address that constitutional issue and say they were not lawfully appointed, it affects not only ALJs here, but I guess in all of those 2,000 or so ones in the Social Security cases and stuff, as to whether the president can fire them. And then, of course, in Collins, court did address it, then said no harm, but at the end of the day, president fired that director. He then had the authority to fire the director and anybody else that would come up there, which previous to Collins did not have. So that's why I say this is an important issue from that perspective if we go there with it. And if we don't, it still seems like to me there's something here.
To address that, Your Honor, first of all, this court decided in Keene not to go there, as you put it, and there's no reason to. It would arguably be an advisory opinion if this court did, right?
Maybe, but think about that, because Judge Harris brought that up, which I think is important, and that is that court in Keene just says we assume that it's constitutional, or assuming if it wasn't unconstitutional, there's no harm. Does that mean we gotta assume it?
I think, yes, Your Honor. I mean, a previous panel decision binds this panel, right? So Keene's.
But they were only addressing the harm in that case, and the fact that that harm doesn't exist, they just chose not to. It didn't say they couldn't. They could have, And nothing in the case said you can't get to the constitutional issue. It chose to say, assuming it was unconstitutional, we'll go there. And we do that all the time. I mean, on this, we assume stuff, and that doesn't mean that someday the court won't come back and not assume it, but simply just address it.
Yes, Your Honor, but my point here is why? Why would the court go and write an arguably advisory opinion about the removal protections afforded to ALJs when it cannot cause any harm in this case and under Keene cannot make any difference in the outcome of the case?
That's
We
what
win
they
either
do that
way.
in Section 1983 cases all the time. There are cases, there are innumerable cases in which the court will go ahead and decide that constitutional issue and then say it wasn't clearly established. It does that all the time. And even here, the reason you would do it is so you will know. If ALJs are unconstitutionally set up, there's a removal procedure that's unconstitutional on it, don't you think we ought to know the answer to that question as opposed to every time it comes up says, well, they could be unconstitutional, but there's no harm to you about it?
Your Honor, so first, Judge Diaz, I'd like leave to take a little bit longer to answer this question as my time is just
Go
about out. But I think, first of all, there's several things you asked there, and I'd like to unpack them one at a time. First of all, Section 1983 cases are not this situation, right? This court has 3 times previously now, we've cited all three cases of this court, decided not to reach that constitutional issue and dispose of the
What are you
case on
talking
harm
about? Section
grounds.
3 times in Section 1983 cases?
No,
not reached?
in this context, okay, so appeals
this
from a
context, okay,
benefits review board decision, 3 previous times. So it may be in other contexts, there are reasons to reach a constitutional issue, but that's not true here. But in terms of the shouldn't we know question, right? I mean, that's sort of, courts generally don't issue advisory opinions just so that litigants know the answer when it's not going to affect the outcome of the case.
If this court holds that it is unconstitutional for an ALJ it would be a lot more than advisory. But the harm you speak of is simply the president says, I want to fire that ALJ. And if that happens, then the harm would be established. Is that correct?
That's what the court said in Collins v. Yellen. Yes, Your Honor. But going back to that, other question you had previously, yes, there is unlike Section 1983 cases here, there is another mechanism, right, to find out whether these removal protections are constitutional, and that's the president can try to fire one of the officers at issue, which the president has done here successfully, right? That's a dual layer removal protection. The president has removed a member of the MSPB, and the DC Circuit last week blessed that removal and said that was constitutional, that the Constitution allowed the president to do that, despite the protections available there. So there is another avenue here. It's not like in a situation where a police officer violates somebody's rights and you don't know if it's constitutional or not or whatever. Here, there is another way to know if these removal protections are constitutional.
Also, aren't we likely to find out, or at least get more information bearing on that question in June or July? I mean, I know we've all been busy, but didn't the Supreme Court just hear a case about removal protections? It seems like if there were ever a need for courts of appeals to jump in and start making some advisory law, this would not be the time, because the Supreme Court is addressing the question even as we speak.
Yes, Your Honor. I think slaughter would be instructive here.
Right.
That's the case involving the FTC. But again, we don't need to even get to slaughter, right? Because the DC Circuit already decided the Harris case, which is about the MSPB,
Well,
which
we're
is the
bound by the
second layer
Supreme Court in
here.
a way we're not by the DC Circuit. So just for our purposes, the Supreme Court is different.
Yes, Your Honor. My point was just that slaughter may not fully answer every
I know,
question.
right, I'm sure,
Yes.
it may not, but I know that this all came up at argument. What are we going to do with the non-Article
Mm-hmm.
III courts? So we may get something on it.
Yes, Your
There's
Honor.
some deeper issues here dealing with the adjudicatory role of the ALJs as opposed to the type of case Collins, for instance, did not, they could have gone there. they didn't go there with the ALJs for that purpose. So something different here. This is a different case than I think what is currently before the Supreme Court, or even in terms of whether Humphrey is still good law. So, but anyway, I'll leave that for another day.
Before you sit down, I just want to briefly get back to this issue of forfeiture, because I was going through the JA, the limited JA, I guess, which only deals with the order on granting benefits. But I did go back and look at the initial order. There was no mention of this constitutional argument before the ALJ or the Benefits Review Board. Wouldn't they have necessarily have to have decided that issue before they got to the merits?
So, Your Honor, just to go through the procedure.
Yeah,
This
please.
is at JA, like 49 to 50 is where the motion was raised to the ALJ in the first instance. The ALJ rejected that motion. I don't have the record site
Okay.
right off the top of my head. After that, there was no reason for the ALJ to address that issue again because the ALJ had already disposed of it. In the first appeal to the Benefits Review Board, there was no need for the Benefits Review Board to address that issue because it wasn't, it had been a denial. And under the Benefits Review Board's jurisprudence, a party does not have to cross appeal to raise alternate grounds for affirmance of an ALJ decision, right? So then the second time before the ALJ, after the board remanded, the second time, that's when opposing counsel again brought it up on behalf of Dominion, and that was again the appropriate time because you have to bring all grounds for vacature of the ALJ's decision to the board if it's your appeal. So that's what happened there, and so that's the procedure that was proper, and that's why the board didn't address it the first time through, and why neither ALJ decision below addressed it, because it was addressed in a separate order in response to the motion.
Okay, thank you.
All right, thank
Mr.
you,
Al-
Your Honor.
Mr. Austin?
Good morning, Chief Judge Diaz, Judges Wynn and Harris. My name's Brad Austin. May it please the court. I'm here today representing the coal miner in this case, Mr. Darrell Mead. Judge Wynn, I think you asked a really good question of my colleague on the other side. What's the standard of review for a reviewing court when an ALJ issues a factual finding? It's whether or not the ALJ stated findings that are rational, supported by substantial evidence, and in compliance with applicable law. The Benefits Review Board has that exact same standard when it reviews a case from the ALJ. And the Benefits Review Board actually supplied a heading that said, look, here's questions that we have that you did not address. And on remand, we need you to address those. That's exactly.
Does the Benefit Review Board have to give deference to the ALJ?
Absolutely, Your Honor. The
Then we have
benefits.
to give deference to the Benefit Review?
This court doesn't give deference to the Benefits Review Board in the same way that it gives deference to the ALJ, because the standards are the same. The Benefits Review Board reviews the fact finder's findings with rational, supported by substantial evidence, and in compliance with applicable law, just like this court does. The BRB in this court reviews on the same standard. The board has to give deference, but this court, I love the way this court has put it in previous cases. There's no duty of long-windedness on an ALJ, but the reviewing court needs to be able to understand what the judge did and why he did it. And so when the board issued the remand, they identified several different issues that were unresolved. As you put it previously, it was a very quick, a non-thorough factual finding. The judge basically said, we have Dr. Adcock on one side identifying a large opacity in the right upper lung zone near the azygous vein, which is greater than 1 centimeter. I do not believe that's complicated pneumoconiosis. We have Dr. DuPont identifying a large opacity in the right upper lung near the azygous vein. I do believe that's complicated pneumoconiosis. And the judge's scrutiny amounted to the following. They're equal, and that's that. That's not enough. That's what the board explained. And in fact, there were several factors that the board could not understand what the ALJ did and why the ALJ did it. The first was that the summary conclusion from Dr. Adcock did not identify the other opacities that Dr. DuPont identified within the lung. In other words, there was not only one opacity, Dr. DuPont said there were several opacities. And Dr. Adcock actually stated that he found other opacities that were of similar size, but he didn't reference those with any kind of specificity. So on review, the board said, well, what did you find with regard to those other opacities? We have nothing in the record that we can understand from what you made a factual finding on.
Just ask a quick question.
Yes, Chair.
Those other opacities, those were not in the pleural area, is that right?
That's what Dr. DuPont said, yes,
Okay.
Your Honor, that's correct. Now, the big question for the ALJ the first time around was this one opacity in the right upper lung that was near the, I don't know if I'm saying this right, it's azygous vein, A-Z-Y-G-O-U-S, I guess it's a zygous vein. And that opacity sort of formed the black and white almost conclusion from the ALJ, but that was really not a fair conclusion for my client. Because see, my client had an expert who was identifying multiple opacities within the lung, and actually the totality of all of those complicated pneumoconiotic opacities was greater than 5 centimeters in size. And so on an ILO form, you actually add up all of those measurements, and when it goes beyond 5 centimeters, it moves into a category B. So on the CT scan, Dr. DuPont identified several opacities. Now, what the judge had before him the first time was Dr. Adcock stating there are other opacities within the lung of similar size, but no mention of what they were or why he believed specifically that those were parenchymal, pseudoplaques and not classified as complicated pneumoconiosis. Now, the other problem with the ALJ's first decision was that he didn't consider the regulatory definition of what is complicated pneumoconiosis. My colleague on the other side says that the regulation does not specifically state that pseudoplaques are a definition of complicated pneumoconiosis, but the problem is the inverse of that is also true. It also does not say that pseudoplaques are not the definition of complicated pneumoconiosis. The definition of complicated pneumoconiosis is when an opacity that was caused by coal mine dust exposure forms that's greater than 1 centimeter. And there's also case law that has addressed this issue. The ALJ didn't address the case law, the ALJ didn't address the regulation, the ALJ did not even identify whether Dr. DuPont and Dr. Adcock were even discussing the same opacity in the right upper lung zone. So what the board did is exactly what a reviewing court should do. The board said, look, our duty is to see whether we can ascertain what the judge did and why the judge did it. We have the following questions. And it gave a list. And contrary to my colleague on the other side's argument in its brief, which I think it's stated this a little differently here today, but throughout the brief, my colleague says that the board reversed the ALJ's decision, and that's completely inaccurate. The board did not reverse anything from the ALJ. What the board did was it said, we need you to identify the following problems that we see and the following factual findings that we cannot understand. And if you find the presence of complicated pneumoconiosis, you should award benefits. If you address all of these things and you still find there is not complicated pneumoconiosis, then you should deny. That's not a reversal, that's a remand.
Can there be a case in which there's substantial evidence to support both positions? In other words, the court could have gone the other way and there would have been substantial evidence.
Absolutely, Your Honor, and I think.
And in this instance, if that is true, does the deference part of our review control that? That even though we would decide it differently, because we believe there's substantial evidence for the other side, the deference drives us to affirm? Is that your position?
Absolutely, Your Honor. I think that's completely fair on what a reviewing court did. And that's why this court, as the board did, affirmed the ALJ's second opinion. Because
it
in the,
becomes rather complicated, and we can talk as though we know what we're talking about when we talk about paper-thin plural nodules counting as complicated pneumococcosis. What do we do? I mean, black lung disease in type cases.
Sure.
What do we do when we have these cases and we have actual fact finders who are listening to the evidence and who is, trying to discern which way to go? And yeah, I think if you look at this record, the other side makes a strong point. There is substantial evidence to go here, but it looks like there's substantial evidence to go. Someone makes the call, and then the deference part kicks in. It seems somewhat unfair because it depends on who's making that call, but that's true here too. Depends on who's making the call here. But, at least in terms of our job, when we're looking at it, is there substantial evidence, an irrational type evidence that supports this point of view? If so, we give deference. And is that in it, even though we might decide it differently?
Judge Wynn, I think that's a fair point, and I think you've identified the very issue that's at the core of this case. But here's what you need to think about in this case. If this administrative law judge, the first time around, would have fully explained his findings and would have made it to where a reviewing court would understand what this judge did and why he did it, then the deference should have been applied. But when a reviewing court cannot read the ALJ's opinion and understand, and I just identified there's about 8 different things that the Benefits Review Board said, we don't know what you found here. We don't know what you were saying here. You didn't look at this here. So there were problems with the ALJ's initial decision. And in fact, when the board remanded the case back to the ALJ, it's the same judge. But when the judge looked at the evidence under the proper standard, which requires, a greater than 1 centimeter opacity, that, is complicated pneumoconiosis. When the ALJ looked at the medical reports and the fact that Dr. Adcock only discussed the one large opacity and Dr. DuPont discussed several others, when the judge looked at all that, the judge actually changed his mind because he reviewed the case the way the ALJ has to review the case and the way that he has to explain himself. So when the board reviewed it for a second time, it could clearly see what the fact finder did and why the fact finder did it. This court absolutely needs to give deference to the fact finder.
Your counsel on the other side puts a lot of emphasis on that first one, and I get it. The reason is because if the first one had gone through, deference was due to ALJ. But it is interesting that when it goes back to the same ALJ, if that ALJ had done it correctly, even in their mind, the redo of it seems like it would have given the same result.
Yeah,
it wouldn't have come with a different result because he looked at the evidence or he did it, or unless he looked at it in a different light, as opposed to what I previously indicated. It appears to me he looked and says, okay, this doctor says this group of doctors says this, it's in equipoise, okay, you don't get any type of, you don't get any presumption or anything from that.
Judge Wynn, I think you're right, and I appreciate what you're saying. It is an interesting procedural history of the case, but I think it goes back to the point you made. The first time, the judge just basically said, we've got one doctor saying this, we've got another doctor saying the opposite. I don't know, there's equipoise, claimant didn't meet his burden. But the thing is, when the board actually considered the case to try to figure out what the judge did, and that bald declaration was insufficient, as I've said, the board said, well, what about this? What about the fact that Dr. DuPont identified multiple opacities, and Dr. Adcock didn't even discuss those? What about the fact that you didn't look at the case law that has also interpreted pseudoplaques as potentially complicated pneumoconiosis? What about the regulatory definition of complicated co-workers pneumoconiosis? What about the fact that, we have other medical reports that are in the case that also provide guidance? Judge, when you look back, the board said, Judge McGrath, when you look at all these things, you've got to explain your findings. And on the second decision, if you'll read the 2 decisions, you will see that the second time around, this administrative law judge went into great detail. I mean, he considered everything. case law, regulation, every single medical report. And his findings were different because he actually looked at the medical reports under the proper legal standard. And when the board got the case for a second time, that standard that I addressed at the outset, can a reviewing court understand what the ALJ did and why the ALJ did it? The board was able to do that the second time because there was actually an explanation from the fact finder. That is the problem, Judge Wynn. The first time around, the reason that the first decision could not be affirmed, and I'm all for deference. I mean, I'm always here. I've been here a lot arguing to this court on black lung cases, and I always lead with that. It's not this court's role to go in and reweigh what the fact finder did if it's supported by substantial evidence. This court can see what the judge did and why the judge did it, so you have to affirm. I argue that to you all the time. I've been up here a lot arguing that. But the board standard is that same exact standard. And on the first ALJ's decision, the board could not do that. That's why it remanded. It identified 8 different questions that were left unresolved. There was no scrutiny of evidence. There was no consideration of regulation, case law. There was no factual finding that the board could understand. And as a reviewing court should, when it can't understand what the lower court did, it sent it back. And the most important thing here is it didn't reverse. It specifically said, look, you can find that the claimant failed to meet his burden. But as a reviewing court, we need to know why. Why did claimant meet his burden? And when the case went back to the ALJ for the second time, the judge did as he was supposed to do. He fully considered the case and reached his findings. So I know I'm almost out of time. I'll just conclude with this. We believe that the ALJ's second decision and order awarding benefits is rational, supported by substantial evidence, and in compliance with applicable law. We ask this court to affirm that decision. Does the court have any additional questions?
Thank you, Mr. Austin.
Thank you.
I believe that Mr. Casserly answered all of your questions on forfeiture.
Yeah, I'm not sure about that, because I went back and looked at the record.
Okay.
It appears that the motion that you made was primarily one challenging the appointment of the ALJ, not removal.
If you look on JA 49, there is
There's a
actually
little flick at.
on 5,
but
yeah.
The ALJ didn't address it, didn't, in his order.
Yeah, and I don't believe the order is actually in the joint appendix itself, and I'm sorry for
Well,
that.
the order is actually, it follows at, let me pull it up here.
Oh, yes, the order denying is on
Yeah.
JA 51,
And it's
correct.
exclusively.
And he did not,
Deciding the appointments clause issue, not any reference to removal.
right.
So
But
I
it's,
guess the question is, again, has that argument been forfeited?
I don't believe so, Your Honor. I think that we were required to raise the argument before the ALJ, and the ALJs have taken the position that they can't rule on this issue because it's a constitutional issue. And so I don't believe that there's any forfeiture because we raised it. The ALJ doesn't have the expertise, and they have said that many times, to address the constitutional question, and the board makes those statements too. And so when we really get to the Fourth Circuit is when these constitutional issues are important for us to address, because this is the court that can address those, and we do believe that it should be addressed. But I do
I'm
not
sorry,
believe that they were
I thought the
forfeited
board did address the issue, the second time.
the second time around.
Yeah, I don't
in its
understand the
opinion.
board to, yeah, I mean, it cited its prior precedent that has addressed this issue and agreed with the Ninth Circuit. I don't understand the board to be standing down from this issue, but maybe,
Okay, and I might have read it wrong, and I'm sorry if
No,
I did,
I-
Your Honor,
okay.
but I don't believe, I believe that this court is the court with the expertise to address that constitutional question, and that's why we brought it here, but I do not believe that it was forfeited in any way, Your Honor. I do want to address something that Mr. Austin said. I know I have a limited amount of time, so I don't want to gloss over anything that the judges really want to talk about. But Mr. Austin said that the reason that ALJ McGrath's decision changed in the award rather than denial is because he actually looked at the record. Although ALJ McGrath does not go into great detail as to why he believed Dr. Adcox was, proved that there was no complicated pneumoconiosis. Dr. Adcock was very specific that pseudoplaques are not pneumoconiosis. In the new award, there was not a lot of detail other than about the pleura. And that was something, nodules in the pleura, that was something the board brought up. So if the board had just said, as Mr. Austin did today, we don't think that you explained this well enough. I need you to go back, I need you to look at the CT scans, I want you to help us understand, because you didn't provide us any good rationale. But they didn't do that. What they said is, you need to look specifically at the location of the nodule and the shape of the nodule. And that's really what a medical expert does for us. A medical expert is the one that explains what the medical community believes to be pneumoconiosis, and that's what clinical pneumoconiosis is. And so that's what the medical community has to do. But, so the board's remand really specifically focused on whether or not a nodule in the pleura can be complicated pneumoconiosis. And like Mr. Austin said, there's nothing in the regulations that say it is. There's nothing in the regulations that say it's not. And so you cannot say Dr. Adcock's opinion was against the regulations, because it wasn't. There's nothing in the regulations that require him to say that pseudoplaques are complicated pneumoconiosis, because that's not true.
So I just want to make sure I understand your position on this initial remand. So
Right.
is your argument that, the board might have said it was just remanding for a better explanation, but in fact, it was like kind of saying what outcome it wanted?
Exactly.
Okay.
Exactly, Your Honor.
If I were to take the board at its word, and just assume the board was actually saying, like, it doesn't look to us like you have actually looked at the content of these experts' opinions and choosing between them, or sending it back, come back to us with more, that would be okay, in
Yes.
your view?
I think what Judge
Okay.
Wynn had said during Mr. Austin's oral arguments is that he looked at it in a different light. Suddenly, we're now looking, the board is saying nodules in the pleura can be complicated pneumoconiosis because they're not excluded from the regulations. They send him over to Fennell, which was a
Can
completely
I just
different
ask, but
case.
Dr. Adcock thinks that if it's, I'm so out of my expertise here, so forgive me, but as I understood it, Dr. Adcock thinks if they're in the pleural area, they can't be complicated pneumoconiosis. Is that not correct?
No, I'm out of time, so I just want to make sure that I can answer.
Please.
Okay. No, what he said is that a pseudoplaque is not complicated pneumoconiosis. Now, a nodule in the pleura, he never said if the nodule is in the pleura, it is not complicated
And that's not your
pneumoconiosis.
position either?
No, our position is that a pseudoplaque, that the experts, Dr. McSherry,
Okay, but
Dr.
your
Adcock.
position is not that it matters whether it's in the pleural area or
No,
not?
no, it's just that if you look at Dr. Adcock,
Okay.
Dr. McSherry's explanations, they fully explained why it's not complicated pneumoconiosis. And you can't say that's against the regulations because it's not. So, I know I'm out of time, so I just would like this court, we ask this court to reinstate the ALJ's original denial and to overturn the board's decision awarding this claim.
All right,
Thank you
thank
very
you,
much.
Ms. Parge. All right, thank you, counsel, for your arguments. We'll come down and greet you and move on to our final case. Our third and final case, 24-1963, Ali versus BC Architects Engineers PLC. Mr. Dolly, whenever you're ready.
Good morning, Your Honors. May it please the court. We're seeking the reversal of sanctions under 28 U.S.C. Section 1927. The defendants sought and the district court granted almost $58,000 in sanctions because we filed an opposition to the defendant's Rule 56 motion in a civil rights employment case for claims under 1981. The district court deemed that because we were not able to show pretext, or under Step 2 of the McDonnell-Douglas standards, sanctions were warranted under 1927. And in the filing of our second appeal, case number 21-1736. Putting aside that we're not aware of any court awarding sanctions for the failure to show pretext, Section 1927 sanctions are also very specific sanctions. These sanctions have got nothing to do with the merits of a case, or that they are warranted because a party has failed to show pretext. Thus, as this court has now twice held in EEOC versus Great Stakes and DeBosch v. Tranny, whether a claim has merit or no merit cannot be the basis for sanctions under Section 1927. Where those sanctions have been awarded is because the parties filed a series of nonsensical motions, deposed unnecessary parties, or in some instances were unprepared for trial or discovery. All we filed was a complaint and an amended complaint. The latter was at the request of the defense counsel. We had no intention of filing an amended complaint. We also held 3 depositions, 2 from the owners of the company and the third of Ali's co-worker, or about less than a total of 7 hours for all 3 depositions. Our Rule 33 and Rule 34 requests were also under the limits prescribed under the local rules of the Eastern District of Virginia. In this case, 22 interrogatory requests and 24 document requests. Under both Great Stakes and DeBosch, that is not multiplication of proceedings under Section 1927.
Is it simply a matter of counting the number of pleadings and activity in a case? Is it your view that a 1927 sanctions motion could never succeed by the filing of one vexatious pleading?
That is the standard that has been held by this court. That is also, we contend that none of our pleadings are vexatious, certainly not in opposition to a motion for summary judgment, which is warranted under the federal rules of civil procedure and the local rules. Yes, so that's our position. Defendants in their brief do not even cite to Great Stakes, nor do they cite to DeBosch versus Tranny, and in fact have conceded that. Moreover, as we stated in our briefs, the plaintiff Nawal Ali had strong circumstantial claims for retaliation. As this court knows, and even the district court held, Ali engaged in protected activity on March 30th, 2016, when she informed the employer of race discrimination at the workplace.
So to be fair to you, in terms of where I'm focusing on this, could just let you go on, but I want to make sure you're addressing my concerns. At the end of the discovery, the district court basically came to the conclusion that you should have known there was no evidentiary support for the retaliation claim. What was the evidentiary support that you had at the end of the discovery that would have supported a retaliation claim?
Sure, I had tons. I had one, the job posting on April 8th, 2016, 8 days after her protected activity. I had the actual term.
What would the job posting have established?
The job posting, this court has held in Gacy, another case of mine, where there is an adverse inference, where there's an adverse action that came on the heels of the protected activity, in this case 8 days, that raises a presumption, and some other circuits have held a strong presumption of retaliation. So I had numerous. The job posting is only one, Your Honor. I had the job posting on April 8th. I had the actual termination followed 8 days later. Then I also had the defendant not following their progressive discipline policy because they forgot or did not know the policy existed. I also had their fraudulent submissions to the Virginia Employment Commission where they stated they spoke to her on January 20th, 2016, highlighting her deficiencies. And when I asked them the deposition, well, what exactly did you speak about her deficiency? What did you say? I don't know. Where did you say it? I don't know. What exactly did you tell her? I don't know. And then the second thing they said in their Virginia Employment Commission, oh, that we also warned her about her job performances on October 2016. That is to say, 6 months after she was terminated, supposedly somebody on their side told her that she was not performing her job. Again, during the deposition, I asked them, what did you tell her 6 months after you terminated her? We don't know. What, so those were the circumstantial evidence that I had to show that defendants had committed retaliation. And I mentioned this in my briefs. I have had, the most recent case of the EDVA was actually less than a year ago in Washington Gas, Young versus Washington Gas, where I had a similar chain of events, except those chain of events were much longer. My clients in Washington Gas engaged in protected activity 4 months before they were terminated. And in Washington Gas, the employer said, we did not only terminate your client, we terminated all 10 of them because of COVID. I prevailed in that motion for summary judgment. The reason I prevailed for the summary judgment was because the district court and the district judge in that court said that the evidence that the defendant produced of my client's poor performance was similar to what BC produced. All of the poor performances in Washington Gas arose immediately after protected activity. Which brings me to another point. In their brief, pages 4 through 6, they cite to the Carville Project, they cite to the Hebrew Project, they cite to the Porterville Project, and the Whitefoot Project. All of them arose after March 30th, 2016, which, as I've said again and again, I've prevailed on those cases numerous times in this circuit and in other circuits when an employer comes and says, right after they engage in protected activity, your employee was horrible. So that is my circumstantial evidence. That was the juice that I had to show retaliation. And I've prevailed in those cases time after time where the employer's motion for summary judgment has been denied twice in this circuit.
May I ask you a question about how your arguments fit together, I guess? I hear you arguing two things today. One is we didn't take any affirmative act to multiply the litigation here, so that's it. And then the other is, well, even if we did, there were grounds for our litigation position.
Absolutely.
How do those two things fit together? Are those alternative arguments?
No, I believe they are part of the same argument under Section 1927. In looking at the case law.
So I'm sorry, so we don't have to decide, let me put it this way. When I look at the statute, it does sort of look to me like you need some kind of an affirmative act that made the proceedings, that multiplied the proceedings.
Mm-hmm.
I do think we have some cases that suggest otherwise, that even just a failure to dismiss your case once you know it's frivolous, you don't do anything to make the proceedings any longer, you just don't dismiss, that might be enough for sanctions. But we wouldn't even have to decide that if you're right about your second argument, that whatever, I had perfectly legitimate grounds for my opposition to summary judgment and my appeal.
You're absolutely right.
Okay.
Yeah.
So in that sense, they're alternative.
Yes.
Okay.
Going on to my, well, I guess I was going to say other evidence pointing to circumstantial evidence. I've already stated that. As again, going to that line of questioning, Your Honor, during the deposition, no one from BC Architects, in this case Brian Quinn or Christopher Morin, told us that Ali was not performing on those 4 projects that arose after March 13. In this case, the Carville, the Hebrew, the Porterville, and the Whitefoot projects. Instead, during their deposition, they simply told us that Ali did not turn in one CAD drawing for the filter project. Now, there are 2 additional things interesting about the filter project. One, it is not listed in anywhere in the affidavits in support of the motion for summary judgment. 2, it is also not listed in their reply brief. So that goes back to the question that Judge Harris rose, and perhaps even that Judge Wynn rose. What was the juice or the evidence that I had to show that they retaliated against my client? They kept, it was like playing whack-a-mole with these guys. Every time I would bust them on something, that something was false, another argument would be raised. In this case, the 4 projects that supposedly came on the heels of a protected activity. That was not what they testified to at the time of the deposition. Not one. Finally, notwithstanding that also Morin had testified in his deposition that Ali did not perform during the filter project or turn in the one drawing, when I deposed Quinn immediately after, and I think his deposition was about less than an hour long, I would say it was about 45 minutes, he told me that he could not identify any project that Ali had fallen behind on. We also talked about the defendant's progressive discipline policy, which they say they did not know. And now that they know that we know, they would like to place my client on a performance improvement plan, which to me, in practice, what they have effectively said is two things. One, we did not follow our progressive discipline policy, and there's so much a case law from this circuit and around the country that when an employer fails to follow their policy, it is circumstantial evidence of retaliation. And that was the second thing I was going to raise about that. Oh, the second thing about that is when they say that they would now like to place my client on a performance improvement plan, they have in effect done what? They have retracted her termination. In which case, great. Bring Ali back to work. They can put her back on a performance improvement plan. I don't know how many months they want to put her on it, but do it. Once again, going to my initial point, I had so much of evidence for retaliation in this case. Finally, the district court again engaged in merits analysis when it held that our appeal was meritless and thus warranting additional fees on the part of BC Architects. As we stated in our brief, only the Court of Appeals can award sanctions for filings made in this court. That has been the standard by almost every circuit in this country. Moreover, there's nothing in this court's one-page order saying that our second appeal was without merit. In fact, as we again pointed out in our brief, the defendant filed a motion for summary disposition with the court, only for the court to deny that summary disposition and asked us to submit our briefs on the merits. We did, and the district court sanctioned us. In short, when in here BC posted Ali's job 8 days after protected activity and fired her 7 to 8 days later, we had circumstantial evidence of BC's retaliation. These two facts alone are sufficient to deny sanctions under 1927. We ask that this court reverse the sanctions order in its entirety. Absent that, it will result in this court being flooded with appeals like this, eviscerating the prosecution of civil rights claims on the fear that if a plaintiff fails to show pretext, they will be subject to sanctions. And the latter is a real concern because a lot of the times, more often than not, employees lose their motion for summary judgment. If there are no further questions, I believe my time is close to being up.
Thank you, sir.
Thank you.
Good morning, may it please the court. I'm Lars Liebler, represent BC Architects. We are now in the fourth appeal of a case that has recently passed the 7-year anniversary, and we're approaching the 10-year anniversary of the day in which BC terminated Nawaz Ali's employment for poor performance. During this time period, the small architecture firm in Falls Church has been saddled with thousands and thousands of dollars of legal fees defending itself from the entirely baseless and scandalous allegations made by Mr. Dali that it discriminated against Miss Ali based on her race and retaliated against her for her complaints made in the workplace. The company owners Brian Quinn and Chris Morin have had to defend themselves from Mr. Dali's repeated ad hominem attacks in which Mr. Dali called them liars, racists, thieves, and crooks. His relentless pursuit of BC is similar to Captain Ahab chasing Moby Dick around all 7 seas when the crew was saying, why?
I mean,
But-
all he did was sue them and then not give up the case, not just dismiss the case voluntarily.
Right.
Like, that doesn't sound Ahab-like.
Well, it does in light of the evidence that was produced during discovery and was available to him probably well before discovery. And I think to answer your question, Judge Harris, the question about the statute in 1927, the cases that have routinely construed that statute in the Fourth Circuit, beginning with Blue versus Department of the Army and many, many cases after that, give it wide latitude. And so although the word multiplication is in the statute itself, the question is, in response to Judge Diaz, it's not a question of how many pleadings you file. It is indeed the conduct of the litigation. And that is what, under the district court found, is the conduct of the litigation, of continuing to fight this litigation after every single factual basis for his claims of both discrimination and retaliation were completely
Well, it seems to get into a
eviscerated.
different area when a case is between the parties. The lawyers are not the parties, they are people who bring the actions and stuff. There are a lot of cases that go on for years and years, and I have the same question, why does this keep taking on and on? And I think there are a lot of instances sanctions could, under these facts, be implicated. But here, the trial judge chose not to, as I understand it, not to award attorney fees and costs under Section 1988. Is that correct?
The judge came to the conclusion that fees and costs were warranted under 1988.
But he chose not to award them under that. And what you've just given would seem to give a basis to award the cost under Section 1988, realizing it's going against the client. But that's what Section 1988 provides for. But this judge said, no, I'm not going to do this against the person who is
Correct.
bringing this action, who's taking the vacations, who's done all of these things that's involved here. I'm going against the lawyer because the lawyer keeps filing stuff. And I think about when a lawyer files stuff, there's some pretty quick ways you can take care of that. You file it, you file a motion and says, you know, Judge, there's nothing to this, it's frivolous. I mean, what do you do? I mean, you know, or, there are a lot of pre-trial motions that can be filed where you don't, particularly after discovery. Now, you say after discovery, it's all out there, there's nothing on discovery. That happens all the time now, of course. You go through discovery, find there's nothing there. Then you come to summary judgment, case over. But here it goes further.
Well, I think that the 1927 statute covers exactly this situation, where you come to the conclusion at the end of discovery, which was February 21st, and every single allegation that was in the three complaints, an original complaint, a First Amendment and Second Amendment complaint, and the basis from which Mr. Dolly was able to obtain the remand and the retaliation, was absolutely and directly refuted.
But there was new evidence that came out, and, you know, you can't change your claims, but if new evidence comes out in discovery, you're allowed to use that, and it did turn up in discovery, right, that there had been this departure from the handbook's progressive discipline policy. Go ahead.
Which the district court found of no moment whatsoever.
Well,
And it had nothing to do with racial discrimination.
By that. I was puzzled by that, given our very clear law that a departure from a discipline policy is indeed circumstantial evidence of retaliatory intent. Same with the shifting explanations. And I know the district court said, look, they all look pretty much the same to me. And for that, he cited 3 cases from the 8th Circuit. And the 4th Circuit were pretty rigorous about that. And those really were shifting explanations. They were not the same. I mean, at that point, we take, this is a weird case because we know this was not a meritorious claim, already lost on appeal.
Right.
But it's not like it was a frivolous claim.
I disagree with you. I disagree.
Okay, you agree that's the standard. Was this a frivolous argument?
Oh,
for
I think that
pretext?
it fell into a bad faith argument. I think that when the crux of this argument was that on March 30th, 2016, this woman came in and complained to the bosses, I don't want to be supervised by SORAB anymore. And in every single complaint at that point from there on was after March 30th, the BC Architects owners decided we're going to retaliate against her. The very next day, and he never put this into any of his pleadings at all, his client must have known about it. The very next day, she emails within hours after this protected activity and says, I'd like to stay at home and work from home today. The BC owner said, yes, please do, happy birthday. That was never revealed. He never responded to it. He ignored it the entire time, other than to sarcastically say, there's no recognized legal defense called the happy birthday defense. We will laugh at that when it goes in front of the jury. He never addressed it in his response. He kept fighting it. The two other items were in every single complaint was that Ms. Ellie made 2 reasonable requests to work from home after March 30, and they were denied. Number one, the first one right after was granted. The next one was April 4th. He claimed all the way to the end that she asked for permission to work from home. The email is right in the discovery. It says, I'm not coming into work today.
I'm not sure how,
BC
I mean, that, you're sort of picking at the record and suggesting that perhaps your colleague on the other side wasn't as forthcoming as he should have been, but how does that amount to an unreasonable multiplication of the pleadings or the case? And related to that, I want to ask you about the district court's order on summary judgment, which, if you read it, I mean, it seems like a pretty sober, reasonable analysis of competing positions with respect to the merits of the claim, ultimately resulting in a loss for the plaintiff, but frankly, no different than most of many other summary judgment motions that or orders that we see. And then all of a sudden, it's like a 180, a motion for sanctions is filed, and the judge has a completely different view of this record. That just struck me as quite odd.
I think he's measured, and he doesn't put a lot of flowery language in there. I think that he has, I think it makes sense for us to jump back for just a moment to what the standard of review is. The standard of review is abuse of discretion. And all the cases that talk about the abuse of discretion with respect to sanctions and attorney's fees make this point. The district court judge has been in this case from the very beginning, from November of 2018 when this was filed. He had full access to the administrative record, which shows that there was much chicanery going on checking every single box, and that this was not a race case, and that once Mr. Dolly figured out that there were fewer than 15 employees and that he couldn't bring a Title VII case, that he changed his theory to race. There's nothing in the administrative record in which this woman made a claim about race in any way whatsoever.
So what's the procedure of this case? This is from November 2018. When was the case dismissed on the merits?
On the merits?
Yes.
In May of 2021.
So about a year and a half later.
No, 18, it's 3 years. It's at least 3 years. It's
21. In 21.
It's 18 to 20, it's 18 to 21. It's nearly 3 years.
I mean, case is filed and you go through discovery. How long did discovery take?
The judge granted a motion to dismiss, and it came to this court. He granted a motion.
But when case is filed in 2018,
Correct.
then when is discovery?
Discovery is in the beginning of 2021, after it returned from this court.
So
The
what
case was
happened between
dismissed.
2018 and 2021?
He re-amended the complaint, changed Syrian to Arab.
Re-amended under what? Under, was it, when you say re-amended, under what rule? 15 or what?
Under 15. We filed a motion to dismiss,
So
and
that's
he amended the
permissible.
complaint.
You can do that.
Right.
You can amend the complaint. So it's amended, and then it's still going on, and you don't have a problem at that point because you haven't gotten it, you haven't gone to discovery yet. And discovery takes place in when?
It takes place in 2021,
So 2021 is, you then have discovery, and how long does discovery go?
3 months.
And then at the end of do you know the month?
The end of discovery was, he had every single document in February of 2021. Can I back up for just?
Okay. You see
Go
where
ahead.
I'm going? I'm just trying to understand the
Yeah,
process.
it was February
Because you make
2021.
out like it's so many procedures and all that's going on. I'm trying to understand. So you got this happening then in 2021. How long after that discovery is it before it actually goes to court and the judge makes a decision in 2021, right?
In May of 2021, we had a hearing on May 5th, 2020.
And discovery had ended what month?
In February.
So April, May, April, every year, March, April, May, 3 months later,
Right.
you then have a case dismissed. After discovery was that's it. From then on, all we're talking about now is sanctions based upon having filed a complaint and wait, it can't be no. It can't be no. Don't shake no about filing a complaint. The complaint was filed in 2018.
It
That's
was
yes,
filed in
right?
2018. I apologize.
Okay. So don't.
I'll tell you why in a moment, why I'm shaking my head
but
no.
I want to check. But that's not it. So 2018, late 2000, you got a complaint. You go through all this time, amended complaint. Nothing wrong with that. That's what plaintiffs do all the time. Come to discovery. Nothing wrong with that. Discovery ends in February. 3 months later, which is pretty quick, he's out of court. He has nothing. You decides, discovery didn't show up anything. When do you say he should have pulled out of it then? If there's sanctions for that 3 months of waiting from the end of discovery until the dismissal, should he immediately after discovery said, all right, I don't have anything, let's don't go back to court?
Correct.
So
Correct.
for 3
And
months.
that's what the judge
So we're
said.
dealing with 3 months of this lawyer failing to, you had 3 months of waiting for the court to say it. That's what we're here for?
It's not based on a calendar, Your Honor. It's based on the fact that he had the information that the case had absolutely no merit whatsoever.
So you're saying
the
after
judge,
every discovery, and it'll change litigation. I litigated back, but it's been 100 years ago, been a long time. After every discovery, if the lawyer, if you go through it and says, well, nothing is here, right then, the lawyer has a duty to file to have that case dismissed.
that's what this court has ruled.
And
May I read?
but if you wait until just a court comes, the next court hearing, which is only 3 months away, court could have had a hearing the next week if you wanted to, if the calendar allowed it. But you just wait until the next one. Nothing is happening. No, whatever's going on, I got it. But if you wait, then the lawyer can be sanctioned for fees for.
But Judge,
Wait.
he didn't sanction him for fees from the beginning of the case. He started, what the
For the 3
statute
months.
says, for the 3 months. That's what he did. Anything from that time period forward, he did nothing before. So he's not being sanctioned for the behavior from the first complaint, Second Amendment complaint, from the first appeal, all that. That's not the subject of his sanctions.
So from then on, he's being sanctioned for challenging the sanction.
No, he has been challenged, no, not for challenging the sanction. That's what this proceeding is.
That's right.
He's
There's
been
no fee,
sanctioned.
There's no sanction being sought for anything other than those 3 months.
In which time we had to prepare a gigantic summary judgment motion.
But I
and
just want to
he-
make sure I understand the time, and I'll leave it alone. The only question here is how much is the sanction for those 3 months awaiting from the end of discovery to the time the judge dismissed the case? Is that it?
He then decided and used his discretion to then decide that it was a frivolous appeal and added those as well. But, so he sanctioned him from the time period, which is totally consistent with the Salvin case in 2008, 281 Federal
So
Appendix
frivolous appeal
222.
took it back to the time he filed.
No, it takes it back to the time that he opposed the summary judgment motion. It was February 21st is when he had every single piece of evidence that showed there
And
was
the frivolous
no merit to
appeal
his claim
was,
at all.
and did he appeal from the merits or did he appeal from the sanction?
It's appeal from the merits.
But then what happens on that?
On that,
Yeah.
he included those fees, and that's completely permissible under this court's ruling.
And those fees are intended to be compensatory, right?
They're compensatory.
Okay,
He
so why,
decided that the
why did,
case-
hold on, why did the judge then decide that you were entitled to your typical fees as opposed to the ones you were actually charging? If they're supposed to be compensatory?
Because it was compensatory because because the company suffered having to pay those fees.
Didn't have to pay them. You gave them a friend of the firm rate, apparently.
Indeed.
Your choice.
I did.
So.
I don't think I think that the case law is pretty clear that when you have a compensatory matter like that and you determine what the value of the services were provided, that's what you.
Well, the best
indeed-
evidence of that is what you charged.
Your Honor, I don't think that has been challenged on the appeal. But I think that it certainly is an indication of what the value
It seems to
is and that they
suggest that
suffered,
this was
so.
punitive, not compensatory.
Okay. Can I answer the question about whether the?
You don't like that question?
I don't like that question.
All right, answer the one you like.
Yeah, I'll answer the one I like, which is that the 6V Generations Federal Credit Union case, which was in 2018, this is the exact same situation where the judge determined that due to misrepresenting the record in front of the judge, that he then applied 1927 sanctions, including for the time period that included an appeal, and then it came back to the court.
Just to clarify, the award of fees here, it doesn't cover anything having to do with the sanctions litigation? I wasn't really clear on how to read the district court on that.
It doesn't include anything on this appeal. I do believe it included me filing the motion for sanctions and arguing that. So it does, yes.
Okay.
And that's permissible under the case law,
Okay,
too.
but it doesn't
File it.
include the appeals on the sanctions?
No, this,
motions?
for the process that we're engaging in right now, it does not.
What about your first appeal? I'm sorry, what about the first appeal from the sanctions motion where you did move before us for fees for that appeal? Can you get fees for that in the district court?
No, I don't think that he didn't award those fees, I don't believe.
Don't
On-
you
when he-
know?
On the fees from when he made the interlocutory
Correct.
appeal, right. I don't recall whether that was included in the fee petition or not. I don't think that it was. I think that it was not. I'm almost positive it was not. I
Okay.
would have to check a record on that.
Okay.
But what he awarded it from was, and again, we have a Rule 60 motion that's pending before you. I wanted to ask that you grant that as well to allow the district court judge to clean up the record. As you see from the Rule 60 motion, on March 31st, he issued in ECF 117 our right to the sanctions fees. And he said the time period begins from the time that he filed his baseless opposition to the summary judgment motion, which included no evidence and ignored all of our evidence. Then, 18 months later, when he said, I'm now going to decide the actual amount of the fees in 3 different places in that opinion, which is the one that we're here before, he then said, I have awarded fees for the preparation of the motion for summary judgment. So he made, it's an error under Rule 60. He needs to reconcile those two and be given the opportunity to fix that error under Rule 60A, and we ask that you grant that motion so he has that ability.
One last clarification in terms of timing. So the case is dismissed in May of, summary judgment, whatever, in May of 2021.
Correct.
And then a motion is made for Section 1988 and Section 1927 fees. When is that motion made?
Shortly after the dismissal.
In the interim, the case is appealed to this court.
Correct.
Then the court waits and does not issue an order on the fees nor the sanctions. He waits until the appeal is over.
Correct.
But could have, I assume, did the court still have jurisdiction to do that at that point, or how did that work?
The court has jurisdiction to determine
do
the fees
fees.
issue after
So it
it's on
could
appeal.
have entered its order or made a determination on whether fees and sanctions, the sanctions were going to be imposed on the council. Council does not know he's going to have sanctions against them, nor does he know that if he keeps this appeal and have those sanctions, he's going to pay not only for those sanctions, but sanctions for the appeal, because there's nothing there. The court has made a determination on this, and then ultimately, once this court makes a decision, remind me, what was our decision on the merits?
Your decision on the merits was simply to affirm without opinion. It said there's no evident error from the record. Summary judgment was properly
We just
entered, and you
issued
affirmed.
a one paragraph.
Correct. It was
opinion.
one paragraph.
And what did it say? Did it say,
It affirmed.
but did it say it affirmed because this is a frivolous matter, or there's no evidence, or it just affirmed?
It affirmed on the basis of the.
It didn't dismiss it, because a dismissal would be, if you dismiss the appeal, then you say, well, it's frivolous, we dismiss it. It affirmed it.
It affirmed it.
Which affirmed the holding on the merits.
Correct.
And then it goes back, and then you calculate the fees.
Yes.
Okay, thank you.
Okay. Final moment, if I may, on that, unless we're running out of time, and that is that I think that the issue about whether the fees could be done for a frivolous appeal by the district court judge is an unusual one, but 6 V Generations, which we cited in the brief, is directly on point for the district court judge having to do so. And the reason why the Fourth Circuit, this court in 2018 did so is they simply said, the fact that 1927 is there, it doesn't restrict him from saying what the proceeding is. And they relied heavily, and this case has been cited on seven subsequent times by the Fourth Circuit for the proposition that this is an abuse of discretion standard, and that the trial judge is the closest one to the conduct of the lawyers to make that determination. So I believe that.
You want fees for the appeal.
Yes, correct.
Well, district court isn't in the best position to assess that.
Well, I think that based on what the abuse of discretion ruling is
To me, that seems like maybe a good reason why you should seek those in the appellate court, the way you did on the interlocutory
correct.
appeal.
And I don't think that they preclude. There's nothing in the statute or in Rule 38 that says this is the exclusive method.
Can you do both?
You could do both.
Well, that
And-
seems like it's going to lead to all kinds of problems.
Well, it's only happened once or twice before, and this court had the opportunity in 2018
What
to
happened
say.
here, right? You came to
no.
us for fees on the interlocutory thing, and we said, no, you're not getting fees. But in front of the district court, you want fees for a different appeal
For
in
the
this case.
substantive appeal. But it's only happened one time. I think that a strict rule saying the district court can only sanction in the district court is too restrictive, and it's not.
Maybe you could have a
it's
strict
not
rule that
consistent
was
with the statute.
that just says the person who wants the fees has to pick their forum. They can't go to the district court on some, the appellate court on some, they can't go to both. Because, I mean, it does seem like there could be a huge
You're reviewing it now, so
problem.
you certainly have the opportunity to review what he said. And I think that if a careful reading of the evidence that he had in support of his position shows, and can I point to, I'll sit down.
You're way over time.
I'm way over time.
Yeah.
Thank you.
Thank you.
I think what was clear from defense counsel's argument is that there are disputed issues of fact, so I'm going to cite to their site in blue. Needless to say, every instance in which a district court credits one side witness over another is not an occasion for sanctions. That's really what this case is about. They have sought sanctions because they don't believe in our facts. I don't believe in their facts. They claim that they have facts, that they did not retaliate against my clients. Where is it?
Why
Yeah.
didn't the court assess fees and attorney fees in the section 1988? Why?
They did not assess.
But why not?
I don't know. I believe the reason for the court was because I believe the reason the district court stated fees under 88 cannot be sought because they sought fees against the client. I believe that was the only reason the court gave, I believe. So then, the defense counsel
Well, that's who
decided.
you should seek fees against the client. The clients wouldn't bring the action,
You're absolutely right.
but
Yeah.
the client can then bring a malpractice action against you.
You're absolutely
if
right.
the client doesn't like the way things went.
You're absolutely right. And speaking of malpractice, that's, I think, the other issue in here, right? I mean, defense counsel has said that, I should have known that, I had no claims for retaliation. Well, 9 times out of 10, I tried similar cases and I've won. And speaking of malpractice, had I withdrawn my motion, had I withdrawn my opposition for motion for summary judgment, which at the EDVA, I just want to be clear, it's next to impossible to withdraw a motion or seek what's the word I'm looking for? File a notice of withdrawal as representation as an attorney. There's no way the EDVA would have allowed me to withdraw from the case when, the entire case in the EDVA is resolved within like 6 months.
So you're saying you can't dismiss a civil action without your client's
Consent.
Consent? That's interesting, that, because he says you should have done it after discovery.
I cannot do it without my, I cannot do it with my client's consent. My client needs to.
Certainly, the action can be withdrawn, but if you dismiss it without, or you could have sought to withdraw from the case, but you got a contract with your client, and you could, and I don't want to get into the attorney-client relationship, but it would require you to disclose to your client if you were dealing with that, but I don't think I want to get in that. That sounds like it's more like a disciplinary type thing than it is here. But there is something in there there's something really messy about the way this is going, because on the one hand, I very well see the point of the other side. The other hand, I see these are not easy cases to bring.
You're absolutely
The
right.
law is not very kind and has
Yep.
not been on these cases. And so when you get lawyers who will bring them, that's a special thing. And to stay in court to be able to bring it is, or even to get it to discovery, it doesn't usually even make it to discovery. It's going to be dismissed on 12B6
Yep.
or somewhere along it because of Iqbal Twombly. You
Yep.
got to do more than just bare allegations.
Yeah, absolutely.
You got to survive a 12B6 to get the discovery on it.
Yeah.
And that's the concern I have is the litigation. Now, whether it sanctions what you did, not to use the word, is another question, because there are allegations of misrepresentations in the record. That would be problematic for the lawyer. But it's an odd case that could carry tremendous implications, and at the end of the day, it presents us with a very difficult decision. It's
Yeah.
not cut and dry for you nor for him from my perspective.
You're absolutely right, Your Honor. It creates negative implications for the plaintiffs' bar, for civil rights attorneys around the country. You're absolutely right. I just want to quickly address on the issue of misrepresentation. The only, I think, misrepresentation I rose, and this was also without the benefit of discovery. My client told me, when I drafted the complaint, that she was not approved for leave on April 4th and April 7th. Post-discovery, we learned that she was 50% right. She was approved for leave on April 4th, not on April 7th. So that really was the extent of the quote-unquote misrepresentation. But having said that, like Judge Harris also stated, post-discovery or during discovery, forget about the April 4th and April 7th, I learned of 6 other ways where they retaliated against my client, which this court did not know during the first appeal, including but not limited to posting of a job on April 8th, not following their progressive discipline policy, stating that she did not perform on these jobs on the, those 4 projects after March 30th, 2016, lying to the Virginia Employment Commission. I was not aware of any of that stuff during our first appeal.
Well,
That only
goes
came to light
another
during
question.
discovery.
When you're held to know what your client, I mean, there may have been things you should have asked your client. I'm not even sure how that all works. I mean, once you get in these cases, a client representations can be different to a lawyer. Tons of time you hear a case and they give you all these explanations, and at the end of it, oh, by the way, or something like that. I don't know the diligence that was used to determine these things here. There may be an issue of what was your diligence in getting this information and what was known to your client.
So on those issues, right, on the issue of the Virginia Employment Commission, the filings that they made, the fraudulent filings that they made with the Virginia Employment Board, my client did not have that information. We got that through discovery. On the issue of the not following their progressive discipline policy, we did not know that. According to them, even they did not know that they had a progressive discipline policy. So that was learned during discovery. On the issue of the Kabul project, nobody, and again, it's in the deposition record. I asked them, when did you raise any of these concerns with my clients? They had no recollection of it. So even they did not have any recollection of these quote-unquote performance deficiencies of my client, yet alone me or my client. Going back on the second issue of the issue of fees, they contracted for $350. That's all they're entitled to, which, based on my calculations, is about $7,000. Finally, the court also needs to take into account, we're a solo practitioner. I submitted 2 years of my tax returns. I made about $40,000. I just submitted my tax returns recently. I don't know what they are. I want to say it's also about $40,000 or thereabouts, maybe about 50. So the court needs to take also our, financial position on this. Again, this court should be greatly troubled. I'll tell you right now, if the court's position is because the defense counsel told your client happy birthday, that has given you conclusive evidence that is not claim for retaliation, that's exactly what happened in Gacies. In Gacies, which was another employment discrimination case, also under Section 1981, the employer did better than what they did. Not only did the employer wish her a happy pregnancy and gave her a nice, beautiful card, not just a smiley face, he also, I believe, gave her a $100 voucher to get some gifts for her baby shower. Did this court says that, Mr. Daly, you should have known that, and because you proceeded with your case, we're now going to grant you sanctions? No, they did not. In fact, what did this court do? Reverse the grant for discrimination, harassment, and retaliation. Point being, the happy birthday defense is nothing. It's not relevant. Employers always have some kind of defense, right? That's under the McDonnell-Douglas burden of production. They will always produce something. May it be happy birthday, happy pregnancy, on the Washington gas card where the employer said your client left a sticky note for the supervisor saying thank you for the treats. In the Chen case, where I got a $650,000 verdict, I couldn't believe this at the time of the deposition, but according to the State Department, their defense was your client in a ballroom in Jakarta danced with the supervisor, and how dare she now claim for retaliation?
Mr. Daly, you're over time, so you need to wrap it up.
All right. That's all I have to say is we ask that the order be reversed in its entirety, and there's no, that there should be no motion for more fees. Thank you, Your Honor.
Thank you. We'll come down and greet you and recess court or adjourn court for the day.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.